So let's go ahead and get started. Good afternoon, everyone, and Happy New Year. My name is Susan Hunt, and I will be moderating today's webinar. Thank you for joining us today. The topic is how to start your own med spa. If you have questions for our speaker at any time, please use the Q&A button at the bottom of your Zoom screen. Keith will address your questions as time allows at the end of his remarks. Now, please allow me to introduce our speaker, Keith Lefkowitz. Keith is a healthcare attorney. He has helped hundreds of clients establish medical practices and wellness clinics, including med spas and IV hydration clinics. He is intimately familiar with healthcare law and regulations, including Texas's Corporate Practice of Medicine Doctrine, Stark Law, the Anti-Kickback Statute, and False Claims Act. Around here, we jokingly call him the walking encyclopedia. Keith began his career interning with the Texas Medical Board and later served as Associate General Counsel for a medical laboratory, giving him hands-on experience with both the business side and compliance side of the healthcare industry. Thanks for speaking with us today, Keith. The floor is yours.
Thank you, Susan, for your kind words, and thank you, everybody, for joining us today. Here's the agenda, and we'll be going over the Texas Corporate Practice of Medicine Doctrine, some ownership models and the entities involved, the licensing and regulation of medical spas, oversight and delegation on the clinical side, advertising and marketing regulations that affect your practice, and lastly, we'll talk about privacy and maintenance of medical records. Following the conclusion of the presentation, we'll go over some questions from the members joining this presentation. Before we get started, I do have to give a disclosure. While I'm an attorney, I'm not your attorney. The slides and information contained herein are for informational purposes only. You are advised to seek your own independent legal counsel. So starting off, the Texas Corporate Practice of Medicine Doctrine and generally across the country, it wants to protect the physician-patient relationship and prevents businesses and unlicensed persons from selling professional medical services or from employing a physician to provide those services and taking a fee directly from the patient. In Texas, when you register your business, it can only be registered for a lawful activity that can be conducted by that business. Medical spas do involve the practice of medicine, and in Texas, the prohibition on the corporate practice of medicine is derived from a handful of regulations and statutes, and those statutes require a person to be licensed to practice medicine. They overall prohibit physicians from aiding unlicensed persons from practicing medicine, including business entities. And they create criminal penalties for persons who falsely indicate in any manner that they're entitled to practice medicine. Non-medical professionals cannot own a medical practice, and you could not form a professional entity, as we'll get into on later slides. But that doesn't mean that you can't be involved in the healthcare industry. As we'll talk about in this presentation, non-physicians can get involved in a management organization and have a direct impact in this industry. So in order to understand when you need to be properly structured on the management model and when you can or cannot own a professional entity that sells medical services, we need to understand what the practice of medicine is. We get a lot of clients asking about cosmetic procedures and other services that they would normally think constitute the practice of medicine, and it does not require you to hold yourself out as being a physician. In Texas, we've had a series of criminal cases involving the unlicensed practice of medicine. In 2005, Dolores Agrippino was convicted of aggravated assault and the unlicensed practice of medicine when she injected several persons with mineral oil, causing severe complications and injuries to those persons. Again, in Texas, we had a woman charged with felony murder for injecting a patient with silicone, which caused an embolism that traveled to her heart and lungs, resulting in the patient's death. In both cases, defense counsel argued that cosmetic procedures don't involve the practice of medicine because the cosmetic procedure is not designed to treat any condition or deformity. As we see here, practicing medicine by law is defined as just attempting or offering to treat a mental or physical disease or disorder through any system or method in the attempt to effect those cures by a person who either professes to be a physician or who directly or indirectly charges money or other compensation for those services. It does not matter if you actually treat the person as long as you're attempting to offering to treat the person and take money for those services, you are practicing medicine. And in those criminal cases, the Texas Medical Board testified for prosecution that the injecting a substance into a person for a desired effect using a prescriptive device to maintain an outcome or to treat what the person may consider to be a deformity constitutes the practice of medicine. And this really shows that it's whether you are practicing depends a lot on the patient's perception. And this is also going to coincide when we talk about marketing and advertising. What does the patient believe that they're receiving based upon the services that you are offering through your marketing and within the facilities where you practice? When you are a non-physician and you want to get involved in the healthcare industry, we always talk about the management services organization model. The MSO is a separate entity, usually a limited liability company, and it does not employ the physician, but it's designed to have the non-physician own a brand. You license your brand name where you're creating this business where the goodwill, where patients will see the goodwill of your trade name for the MSO, although they're receiving services directly from a physician in a physician-owned PLLC. The types of entities that can be set up for an MSO involve a for-profit corporation or a limited liability company, whereas the physician would own a professional entity, either as a professional limited liability company or a professional association. In this case, the management services organization, in addition to licensing its brand, could offer office space, equipment. It could provide administrative and management services such as billing, HR, and other services between this MSO and the medical practice that is owned by the physician. Again, to sum up, in Texas, based on the prohibition on the corporate practice of medicine, a non-physician cannot directly employ a physician to sell those medical services through a medical director agreement or otherwise, but we can set a non-physician as the owner of a management services organization that provides management services to a physician practice in exchange for a management fee. We get a lot of questions from prospective clients and existing clients about a facility license, and this often comes up from cosmetologists, estheticians, or laser hair removal professionals. And that is because the Texas Department of Licensing and Regulation regulates cosmetology and laser hair removal professionals and facilities. If you want to establish a cosmetology establishment or laser hair removal facility, you need a license for both the building itself and the professionals involved with delivering those services. Whereas a medical spa is primarily regulated by the Texas Medical Board. A physician office does not require a separate facility license. The medical board only provides a license for the physician, him or herself. Similarly, a nurse can only receive a nursing license for the individual, not an establishment license for a nursing facility. We often get questions about private certification. You may have seen or worked with somebody who's certified Botox injector. This does not equal state licensure, and it does not allow you to operate or own a medical spa. Again, a medical spa can only be owned by a licensed physician because we are involved in the practice of medicine and the delivery of professional services. In addition to the professional licensing requirements, when you operate a medical spa, you want to make sure you're complying with other relevant laws and regulations such as OSHA when it comes to bloodborne pathogen rules and hand washing and hygiene. Now that we've formed the business and established your ability to operate on the administrative side and in the overall structure, you need to consider the clinical side of the house. The Texas Occupations Code does grant a physician wide authority to delegate medical acts to unlicensed persons. And so long as the delegation is to a qualified and properly trained person, and the act can be properly and safely performed by that person, is performed in its customary manner, and the delegation is not in violation of any other statute, and the person to whom the delegation is made does not represent that they're authorized to practice medicine. It's really important that we see that the delegation must be to a qualified and properly trained individual. This general delegation authority does not have any limitations or express limitations on the specific training, certification records of the individual who receives that delegation authority. No matter how the business is structured, whether you're utilizing the MSO model or a direct medical director model, whether it's structured properly or improperly, the delegating physician remains responsible for the medical acts of the person performing the delegated medical act. Now that we've looked at the general authority of a physician to delegate, we can look at the Texas Medical Board rules for non-surgical medical cosmetic procedures. These regulations fill in a lot of blanks for the specific medical spa procedures, such as Botox, derma fillers, use of various medical devices for cosmetic procedures, such as cool sculpting. In these rules, the medical board requires for the physician or a mid-level practitioner to perform an examination of the patient, to make a diagnosis, to develop a written treatment plan. And those items, among other items, must be accomplished prior to any other person performing that injection, such as an individual who may have received a certified injector certification from a private organization. These rules do not require the physician or mid-level practitioner to be on site, so long as the delegating physician is available for emergency consultation with that person performing the procedure and an emergency appointment with the patient. In reality, if an emergency occurs and if the physician or mid-level is not on site, it will, the physician and mid-level will not have a real capability of providing or managing that emergency situation. And that is borne out in Texas Medical Board sanctions, where the medical board notes the distance between the supervising physician and how they were unable to help manage or treat the complications of the patients. That is seen here with this individual, with Dr. Baluch, who was sanctioned in 2023. And again, before we talked about the general authority of a physician to delegate, that must be given to a person who's not just licensed, right? There was no specific licensure requirement, but who is properly trained in the procedure that was delegated to them. In this case, Dr. Verhalen delegated a procedure to a physician assistant who you would assume is capable of performing whatever procedure was delegated to him by the physician, the supervising physician. But in this case, the licensure was not what was critical. It was the fact that the physician assistant was not capable of performing the delegated medical act. Well, what about IV hydration? IV hydration is not included within the definition of non-surgical medical cosmetic procedures. So since that medical board rule has specific requirements, required for the physician to examine the patient, to come up with the treatment plan prior to the administration of the Botox injection or the use of the medical device. We see a lot of times and hear a lot of from a lot of prospective customers that IV drip bars don't follow that protocol, that they utilize standing delegation orders. So recently, in October of 2023, the Texas Medical Board published an article talking about how IV hydration does involve the practice of medicine and may not be based upon this menu ordering without an appropriate assessment of the patient by a qualified individual. This is obvious when you look at the medical board rules relating to the administration of a prescription drug. And those rules state that a physician may only administer or delegate the administration of a drug that are in the physician's medical judgment therapeutically beneficial or necessary for the patient's treatment. And there are sanctions available for physicians who provide medically unnecessary services to a patient. And those sanctions are considered, or that act is considered unprofessional and dishonorable conduct by the physician. Standing delegation orders combined with menu ordering creates a situation where a patient gets to select whatever treatment they want without being examined. Standing delegation orders are defined in the medical board rules as instructions, rules, regulations that are prepared by a physician and designed for the person's, like a nurse or some other person completing those orders prior to being examined or evaluated by the physician. In order for the physician to generally determine medical necessity, he or she would have to examine the patient and, order or perform certain diagnostic tests, as an example, to investigate and evaluate the patient's chief complaint, to formulate a diagnosis, and to establish a treatment plan. By having a standing delegation order for the administration of an IV prescription drug without performing the examination, coming up with a diagnosis, and establishing a treatment plan, we've really bypassed a lot of the safeguards that are designed to protect patients. On top of that, the standing delegation order definition and the rules associated with that definition limit the scope of what can be contained within those orders. Pre-signed prescriptions are permitted so long as they're limited to these items, such as oral contraceptives, diaphragms, some topical antiparasitic drugs, or other certain drugs that, are really kind of in the public health treatment bucket. But none of these items relate to IV vitamin hydration. Okay. So again, a lot of people utilize standing delegation orders and will screen in those orders for contraindications, which is designed to ensure that the drug doesn't harm the patient, but they don't, and by utilizing a standing delegation order without examination, the physician is unable to determine medical necessity, which is just as important as screening for contraindications. So the too long didn't read version of this, the medical board and the occupations code allow for the physician to delegate many medical acts to various persons that are licensed or unlicensed, so long as the delegated medical act is performed in its customary manner, is performed by somebody who's qualified and properly trained in performing that act, and so long as the standard of care is followed, where the physician can examine the patient, or a mid-level practitioner can examine the patient, formulate a diagnosis, establish a treatment plan, and ensure the safety and protection of that patient. All right, so we set up your medical spa. We have the structure. You have an MSO. If you're non-physician, if you're physician-owned, you're just set up in a professional practice. We've gone over the clinical side to ensure that services are delivered in accordance with the standard of care, that patients are receiving legitimate medical services in a safe and effective manner. Now we need to bring patients into the business. You want to market your business. The Federal Trade Commission governs and regulates a lot of the marketing that occurs in the healthcare space. When you make a healthcare claim, that is a material claim to the patient on their decision to seek out your services. And the Federal Trade Commission is looking for substantiation. They're going to evaluate the totality of your claim. And they sometimes distinguish between efficacy claims and establishment claims. Like in this advertisement here, we have a physician talking about, representing that the physician establishment recommends this product, right? That's going to require a higher level of substantiation than just a general, this product might generally improve your health type of claim. But in either case, if you don't have substantiation, if you don't have, peer-reviewed medical journals referencing, or if you don't have independent clinical trial evidence supporting your claim that this product specifically prevents, mitigates, or cures this condition or disease, and yet you make that claim, whether it's express or implied, the FTC might consider your claims to be false, deceptive, and misleading. And that's exactly what happened recently in Texas, when the FTC brought an action against an IV bar for marketing various cocktails as treating, curing, and mitigating the effects of various diseases. And in this case, as part of its settlement action, the IV bar was required to send a follow-up notice to its customers, specifically stating that even though it had marketed, for example, the Myers cocktail as providing some benefits to treat serious diseases, it did not, in fact, have any evidence that the Myers cocktail could treat those serious diseases. And so in that, as you can see, taking the FTC marketing rules seriously is important for protecting your brand and ensuring that you avoid legal scrutiny and enforcement action. Lastly, once you've set up your business, you've brought in the customers, you have the clinical operations going, your nurses, your medical, your physician assistant or nurse practitioner are starting to create customer records. If you're in the physician, or if you're in the medical industry, you're familiar with HIPAA. If you're not in the medical industry, if you're not licensed, you may not be familiar with HIPAA, although you might have heard of it. HIPAA is a federal statute. It only applies to covered entities, which are health plans, clearinghouses, and providers involved in the submission and exchange of electronic transactions. So when you go to the doctor and they submit a claim to insurance for reimbursement, in that situation, the physician and the payer would be covered entities, and they're obligated to protect the health information of the patient. And that relates to your payment information related to the treatment that you received, the information regarding your treatment. So let's assume a medical spa, if it were covered under HIPAA, the Botox that you received or the cool sculpting and anything else that you provided that relates to your past, present, or future healthcare. If you are not a covered entity under HIPAA, that doesn't mean that you're out of the woodworks. You still have to provide privacy and security protections to the information you collect. Texas has the Medical Records Privacy Act, which has adopts and kind of mirrors HIPAA, but has a much broader coverage for what a covered entity includes. Whereas in HIPAA, you may have heard of a business associate who provides certain administrative services on behalf of a covered entity and maybe collects or receives, maintains, or creates that private health information. Maybe you're a third-party biller or a law firm, and you would be considered a business associate. Those types of entities are considered a covered entity under the Texas Medical Records Privacy Act when they create, collect, or use that type of information. And then lastly, if you're a physician, it's always it's not enough just to rely on your management services organization for the maintenance of these records. Physicians are directly responsible through their licensing regulations to maintain such medical records for a period of 7 years. And thank you guys for joining this presentation. This concludes the information on how to establish and maintain your medical spa.
Okay, now we're going to open it up to questions. Thank you, Keith. We've had some really good questions come in while you were making your remarks. As a reminder, if you do have a question, please use the Q&A feature at the bottom of your Zoom screen, and we'll continue to address those as they come up. Our first question, Keith, is about a physician assistant. Can a physician assistant own or jointly own a med spa, the professional side?
Yes, the physician assistant is permitted by the Business Organizations Code to jointly own a physician practice, so long as the physician assistant doesn't own more than a minority interest. If there are more than one physician assistant, more than one physician involved, no physician assistant can have a greater interest than any other physician, and that's designed to ensure that the PA can't interfere with the decision-making of any physician in that practice. There is no similar exception for joint ownership between an APRN and a physician.
All right, appreciate that. Next question, must a physician or delegated practitioner perform a consultation before each and every IV treatment?
Generally, yes, in the sense that a new patient needs to be examined by somebody with prescriptive authority. When you use a standing delegation order for a general population, like we went over in the slides, that's designed for use prior to evaluation. There's another term called a standing order. Once you've evaluated the patient once, if the ordering practitioner believes that it's medically necessary to have multiple infusions throughout the course of a year, for example, that ordering practitioner could write an order for, one infusion a week for 3 months, whatever they deem medically necessary. And then in that case, the patient would not have to be examined each time to establish medical necessity for the entire order.
Okay, thank you. Next question. This is a long one. One of the requirements of the rule for non-surgical cosmetic procedures states that the physician delegating must be trained in this procedure. We see pushback from physicians or medical directors on this. They refuse to be trained in Botox and vaginal rejuvenation, for example. Do you think their training is essential, or would their medical license suffice to satisfy this requirement of the rule?
That rule was adopted by the medical board, which is responsible for governing their license. And that rule specifically governs these types of procedures. It is not enough just to be licensed. And that is no different from a physician saying, well, I'm, a licensed and trained physician. Even if I'm family medicine, I can perform plastic surgery, or I can perform brain surgery, or I can perform, cardiology. So just being licensed is not enough. And you are limited to practicing within the scope of your training and education and experience, just as much as there is a licensing boundary between non-physicians and physicians. For the non-surgical medical cosmetic procedures rule in 193.17, it does require a physician to have specific hands-on training for every procedure. And if your collaborating physician is not getting trained, I would not provide those procedures, because you're going to run afoul of that requirement and the related supervision requirements.
Awesome. Thank you so much, Keith. Next question. Is an optometrist considered a physician for med spa ownership, or is an MSO required?
No, and there's a difference between an optometrist and ophthalmologist, but no, an optometrist is not a physician. The medical board, if you did not receive a license from the Texas Medical Board, you would not be considered a physician. Now, the Texas Business Organizations Code does allow joint ownership between some different professions, not just a physician assistant and a physician. I believe under certain circumstances, a physician and a dentist or a chiropractor, for example, could own some joint entities potentially, but there are strict barriers ensuring that each professional individual only performs their scope of licensure and don't interfere with each other's scope of practice. Of course, before establishing any joint practice, we'd want to carefully review the applicable provisions of the Business Organizations Code providing for joint ownership before establishing any type of entity.
Outstanding. I think our audience can understand why we call you the walking encyclopedia. Next question. Does the business structure have to be a PLLC, or can it be an LLC, and why?
Okay, so the MSO can be an LLC. That's a limited liability company without the P, which means it doesn't provide professional services. In the slides, we talk about, well, a business must be registered for a purpose that is permissible under law. So the analysis starts with the administrative code, which contains that first narrative description of the corporate practice of medicine, and says that no business can hold itself out as practicing medicine without a license. That precludes an LLC from being formed for the provision of professional services. Then you look at the professional, business formation rules under the organizations code, and that limits ownership of a professional entity to persons that hold a professional license for rendering the same service offered by that entity. So taking that all together, if you want to offer a professional services, it would have to be a professional entity. For a physician, you cannot form a professional corporation. It would have to be a professional limited liability company or professional association. If you're not a physician and you want to own the MSO, that would have to be an LLC or a professional or a for-profit corporation.
Thank you for reviewing that. The next question is, how can House Bill 3567 affect my med spa if I am only an RN?
Okay, I don't have that House bill in front of me for review, so I can't really opine on that. if
Yeah, it's
I
it's,
would,
from what I understand, it's a proposed bill introduced this year, so
Okay.
we may have to revert back on that one.
you beat me to it. What I was going to say is there were a lot of proposed bills that could have impacted a medical spa, but if the bill was not adopted and signed into law, then it has no impact. It's as if it didn't. It has the same effect as if it wasn't proposed at all. And so if it wasn't, if you go in and there's the Texas legislature allows you to look up a bill. And if it was, you can see if it was signed into law or not, and that would give you your answer as to whether it would have any impact on your medical spa.
Thanks for clarifying. Next question starts out with a compliment. Thank you for an excellent presentation. You mentioned that going through the insurance for payment requires HIPAA compliance. Is it different for services without using third-party payers, like out-of-pocket payment?
So the HIPAA definition of covered entity requires that electronic transaction, typically cash pay businesses that do not accept insurance would not necessarily be a HIPAA covered entity. But again, that doesn't save you from having to adopt the same types of protections for the protected health, for the health information that you collect, because Texas does have the Medical Records Privacy Act, which prohibits you from exchanging information without, certain conditions. And it does adopt, the same permissions that are included within HIPAA itself.
Thank you. Next question. After a good faith exam is done using a service like Spa Connect, can a nurse or esthetician then create a treatment plan with the services we provide?
So a couple of things there. An esthetician is not capable of performing a treatment plan because an esthetician is licensed through the TDLR as under the cosmetology regulations, and is not a licensed practitioner under the Texas Medical Board with prescriptive authority, or under the Texas Board of Nursing with prescriptive authority, like a nurse practitioner who can have prescriptive authority pursuant to a delegation and supervision agreement with a physician. So once the good faith exam has occurred, we still need somebody with prescriptive authority to order the drug or procedure. If the third-party entity, such as Spa Connect, is not providing that ordering service, then the good faith exam is not enough to initiate that first IV hydration or Botox procedure. If you're utilizing good faith exams pursuant to a standing order, like we talked about with a previous, somebody else who asked that question about standing delegation orders and standing orders, and it was just for, are we screening the patient for contraindications only, but then we're relying upon an existing standing order that was ordered by somebody like a physician or a PA, then that might be appropriate.
Okay, thank you. Next question, another standing order question. With standing orders on Botox or temporary fillers, will I be covered and not seen as, quotes, practicing medicine, close quotes?
I don't know who the I would not be covered would be and what your licensure is. And so a standing order, again, would be dependent upon the standard of care for that service. The physician, nurse practitioner, or physician assistant would have to ensure that the standing order for Botox, whether it's 1, 2, 3, or 4 times, is consistent. If the standard of care requires physical examination each time, even though the injection itself does not require a separate order by the physician, we'd have to follow those rules. If the person who wants to fulfill that order, such as a registered nurse or other person who's operating in that physician practice, you can follow a standing order. Now, if you're a registered nurse, those rules require that you ensure that the order is appropriate, in the sense that if you ever feel as a registered nurse that the standing order or any other order from a physician is inappropriate for any reason, then you have to speak up or not complete the order. But once you have that order and you think it's okay, then yes, you could fulfill the order written by your supervising physician.
Thanks, Keith. Next question. What are the appropriate legal steps to become a Botox trainer independently, or is that possible?
I think that's outside the scope of my wheelhouse on becoming a Botox trainer, but that's certainly something that we can investigate.
Okay. And final question, and again, if anybody has any other questions, please submit them using the Q&A button. We've got a few more minutes. The final question I have is, can patients be examined and diagnosed via telemedicine?
Yes, absolutely. So again, this comes down to the standard of care. So something like Botox, a plastic surgeon might want to examine, the patient's face, or any other medical, let's say you're doing cool sculpting or some kind of other procedure that affects directly the body. It's easy to see how the ordering practitioner might want a physical in-person examination. Something like IV hydration, that the ordering practitioner might not require, pursuant to the standard of care, a physical examination, could potentially order the infusion through telemedicine. There are specific telemedicine laws and regulations. Among those are having a HIPAA compliant security platform. Also, the standard of care that would apply in that in-person setting would need to be consistent on that telemedicine visit, making sure, again, that, that procedure, that infusion therapy is consistent with the medical standards of care.
Thank you so much, Keith. Oh, good. We just got another question. For your service, what all does it include? I think they're talking about like for your services, Keith. We are a med spa up and running under an LLC that has a medical director, SDOs, etc. I have spoken with other firms and they strictly do the MSO PLLC creation. Y'all help with other areas of compliance as well?
We do, and anybody who's listening in is welcome to call in. We'd be happy to set up a brief call to describe our services, or if you'd like a more in-depth discussion, we can schedule a consultation. We're not limited to just setting up a business entity. We want to provide you with counseling and education and any other ancillary documents that may be needed for the business on the MSO side or the physician side.
Terrific. Appreciate it. And I don't see any more open questions. So I'm just going to thank everyone for attending today's program. Keith and I really appreciate the questions, the participation, the interaction. If you haven't already, please take a moment to jot down Keith's contact information. You can also scan the QR code on your screen to connect with Keith on LinkedIn. That way, if you ever need him, you can contact him easily. And with that, we just want to thank you again, and we hope we'll see you next time. Thanks, everybody. Enjoy your afternoon.